One of the first Second Amendment cases out there is this one from 1939, United States versus Miller. It is not a sweeping Second Amendment case like the Heller decision or perhaps the Bruen decision later in 2022, but it is a major decision because it would be continued and extended by both of those later 2008 Heller case and the Bruen decision and rebaptized into this new lineage of what is the Second Amendment. So in that sense, it's kind of the first Second Amendment case, and it's a short one too. Now on this channel, you will see two other videos where I go into the entire background, which is extreme and salacious and quite weird on this case. And then a second one where I go into the actual decision as far as explaining and interpreting the outcome, how is it later baptized into Heller and extended through Bruen and so forth. So how does Miller exist with us today and how will it exist with us moving forward? You have to check out those two videos linked in the description box below. Hopefully you've seen some cards flash up and you'll see at least one of them at the end of the video. They're very interesting. In this one, we're going to be doing the audiobook version of Miller. So let's get into it. Mr. Justice McREYNOLDS delivered the opinion of the court. An indictment in the District Court, Western District, Arkansas, charged that Jack Miller and Frank Layton, quote, did unlawfully, knowingly, willfully, and feloniously transport in interstate commerce from the town of Claremont in the state of Oklahoma to the town of Siloam Springs in the state of Arkansas, a certain firearm, to wit, a double-barreled 12-gauge Stevens shotgun, having a barrel less than 18 inches in length, bearing identification number 76230. Said defendants, at the time of so transporting said firearm in interstate commerce, as aforesaid, not having registered said firearm as required by Section 1132D of Title 26 U.S. Code, and not having in their possession a stamp affixed written order for said firearm as provided by Section 1132 Sub C, Title II, United States Code, and the regulations issued under the authority of the said Act of Congress known as the National Firearms Act, approved June 26, 1934, contrary to the form of the statute in such case made and provided and against the peace and dignity of the United States. Quote, a duly interposed demurrer alleged the National Firearms Act is not a revenue measure, but an attempt to usurp police power reserved to the states, and is therefore unconstitutional. Also, it offends the inhibition of the Second Amendment to the Constitution. Quote, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The District Court held that Section 11 of the Act violates the Second Amendment. It accordingly sustained the demurrer and quashed the indictment. The cause is here by direct appeal. Considering Sonzinski versus United States, 1937, and what was ruled in sundry causes arising under the Harrison Narcotic Act, the objection that the Act usurps police power reserved to the states is plainly untenable. In the absence of any evidence tending to show that possession or use of a shotgun having a barrel less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Certainly, it is not within judicial notice that this weapon is any part of the ordinary military equipment, or that its use could contribute to the common defense. Imet versus State. The Constitution, as originally adopted, granted to the Congress power, quote, to provide for calling forth the militia, to execute the laws of the Union, suppressing insurrections and repel invasions, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress, unquote. With obvious purpose to assure the continuation and render possible the effectiveness of such forces, the declaration and guarantee of the Second Amendment were made. It must be interpreted and applied with that end in view. The militia which the states were expected to maintain and train is set in contrast with troops which they were forbidden to keep without consent of Congress. The sentiment of the time strongly disfavored standing armies. The common view was that adequate defense of country and laws could be secured through the militia. Civilians primarily, soldiers on occasion. The signification attributed to the term militia appears from the debates in the convention, the history and legislation of colonies and states, and the writings of approved commentators. These show plainly enough that the militia comprised all males physically capable of acting in concert for the common defense. Quote, a body of citizens enrolled for military discipline, quote. And further, that ordinarily, when called for service, these men were expected to appear bearing arms supplied by themselves and of kind in common use at the time. Blackstone's commentaries points out that, quote, that King Alfred first settled a national militia in his kingdom, end quote, and traces the subsequent development and use of such forces. Adam Smith's Wealth of Nations, Book 5, Chapter 1, contains an extended account of the militia. It is there said, quote, men of republican principles have been jealous of a standing army as dangerous to liberty, end quote. Quote, in a militia, the character of the laborer, artificer, or tradesman predominates over that of the soldier. In a standing army, that of the soldier predominates over every other character. And in this distinction seems to consist the essential difference between those two different species of military forces, end quote. The American colonies in the 17th century affirms in reference to the early systems of defense in New England, quote, in all the colonies, as in England, the militia system was based on the principle of the assize of arms. This implied the general obligation of all adult male inhabitants to possess arms and, with certain exceptions, to cooperate in the work of defense. Quote, the possession of arms also implied the possession of ammunition, and the authorities paid quite as much attention to the latter as to the former. Quote, a year later, 1632, it was ordered that any single man who had not furnished himself with arms might be put out to service, and this became a permanent part of the legislation of the colony Massachusetts, end quote. Also, quote, clauses intended to ensure the possession of arms and ammunition by all who were subject to military service appear in all the important enactments concerning military affairs. Fines were the penalty for delinquency, whether of towns or individuals. According to the usage of the times, the infantry of Massachusetts consisted of pikesmen and musketeers. The law, as enacted in 1649 and thereafter, provided that each of the former should be armed with a pike, corselet, headpiece, sword, and knapsack. The musketeer should carry a good fixed musket, not under bastard musket bore, not less than 3 feet 9 inches, nor more than 4 feet 3 inches in length, a priming wire, scourer, and mold, a sword, rests, bandoliers, 1 pound of powder, 20 bullets, and 2 fathoms of match. The law also required that 2/3 of each company should be musketeers, quote. The General Court of Massachusetts, January Session 1784, provided for the organization and government of the militia. It directed that the trained band should, quote, contain all able-bodied men from 16 to 40 years of age, and the alarm list all other men under 60 years of age, end quote. Also, quote, that every non-commissioned officer and private soldier of said militia, not under the control of parents, masters, or guardians, and being of sufficient ability therefore in the judgment of the selectmen of the town in which he shall dwell, shall equip himself and be constantly provided with a good firearm, end quote. By an act passed April 4th, 1786, the New York legislature directed, quote, that every able-bodied male person, being a citizen of the state or of any other United States and residing in this state, except as such persons as hereinafter excepted, and who are of age 16 and under age of 45 years, shall, by the captain or commanding officer of the beat in which such citizens shall reside, within 4 months after passing of this act, be enrolled in the company of such beat, that every citizen so enrolled and notified shall, within 3 months thereafter, provide himself, at his own expense, with a good musket or firelock, a sufficient bayonet and belt, a pouch with a box therein to contain not less than 24 cartridges suited to the bore of his musket or firelock, each cartridge containing a proper quantity of powder and ball, 2 spare flints, a blanket and knapsack, end quote. The General Assembly of Virginia, October 1785, declared, quote, the defense and safety of the Commonwealth depend upon having its citizens properly armed and taught the knowledge of military duty, end quote. It further provided for organization and control of the militia and directed, quote, all free male persons between the ages of 18 and 45, end quote, with certain exceptions, quote, shall be enrolled or formed into companies. There shall be private muster of every company once in 2 months, end quote. Also, that, quote, every officer and soldier shall appear at his respective muster field on the day appointed by 11 o'clock in the forenoon, armed, equipped, and accoutred as follows. Every non-commissioned officer and private with a good, clean musket carrying an ounce ball and 3 feet 8 inch long in barrel, with a good bayonet and iron ramrod, well fitted thereto, a cartridge box properly made to contain and secure 20 cartridges fitted to his musket, a good knapsack and canteen, and moreover, each non-commissioned officer and private shall have at every muster 1 pound of good powder and 4 pounds of lead, including 20 blind cartridges, and each sergeant shall have a pair of molds fit to cast balls for their respective companies, to be purchased by the commanding officer out of the moneys arising on delinquencies, provided that the militia of the counties westward of the Blue Ridge and the counties below adjoining thereto shall not be obliged to be armed with muskets, but may have good rifles with proper accoutrements in lieu thereof, and every of said officers, non-commissioned officers and privates, shall constantly keep the aforesaid arms, accoutrements, and ammunition ready to be produced whenever called for by his commanding officer. If any private shall make it appear to the satisfaction of the court hereafter to be appointed for trying delinquencies under this act that he is so poor that he cannot purchase the arms herein required, such court shall cause them to be purchased out of the money arising from delinquents." End quote. Most, if not all, of the states have adopted provisions touching the right to keep and bear arms. Differences in the language employed in these have naturally led to somewhat variant conclusions concerning the scope of the right guaranteed, but none of them seems to afford any material support for the challenged ruling of the court below. In the margin, some of the more important opinions and comments by writers are cited. We are unable to accept the conclusion of the court below, and the challenged judgments must be reversed. The cause will be remanded for further proceedings. Mr. Justice Douglas took no part in consideration or decision of this case. So there you have it, in all of its wordy, quotey, technical glory, 1939 U.S. versus Miller. As you can say, they don't make them like they used to. If it was difficult for you to listen to, I assure you I did the best I could. Hopefully the words on screen helped as it worked its way through. If you prefer to give it a good read, it is linked in the description box below. You will see what I was dealing with, however, so be sure to check that out if you'd like. This remains an important case that is still cited back to by district courts, by federal circuit courts of appeal, by United States Supreme Court, you name it. This case is not going anywhere. So it's useful to be able to be familiar with it because Lord knows it's going to keep coming back. Be sure to hit that like button, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.